As you can imagine, after that occasion, I have not had the pleasure of wearing my wig again, and I have only grayed now so much that I'm not even so sure that I need a wig if I do show up again at the Supreme Court. I'm extremely grateful to the firm of Wole Olanipekun Co, conveners of this important conversation on our system of administration of justice, for this very kind invitation. Chief Wole Olanipekun is without doubt one of the most consequential lawyers in not only in our country, but perhaps even in the Commonwealth. Today, his exceptional success with novel constitutional constructs is swiftly becoming the stuff of legend. But these days, he is doing his best, and I want him to listen to this very well. These days, he's doing his best to enjoy the very huge fruits of his labor, and has sensibly handed over the tougher parts of running the law firm to his two exceptionally brilliant chiefs of the old block, Dr. Dapo Olanipekun, Senior Advocate of Nigeria, and Mr. Bode Olanipekun, Senior Advocate of Nigeria. I commend you both for this exceptional idea and the execution of this summit. This theme covers a very broad remit, and just after listening to Odita covering the wide range of issues and with such incredibly appropriate examples and illustrations, one really would rather not say anything. We'll just go straight to the discussions so that we can make our contributions. So what I will try to do is to focus my comments on the responsiveness of our system of administration of justice to the ends of social justice, or the social ends that is to serve. And I'll just mention a thing or two about some of the other infrastructural issues at the end of my presentation. We are, at a moment in history like no other, a global pandemic of a magnitude probably never seen before, and the worst global economic decline in a century. But economies, like politics, is local. Here in Nigeria, we were already grappling with issues of poverty, entrenched inequality, disparities in access to social and economic opportunities, constraints to access to justice, and I think as Fidelis said, not just access to justice, but perhaps more importantly, exiting justice, the justice system, and the diminishing faith in governing institutions generally. At the same time, insecurity in parts of the country stretching our law enforcement infrastructure to its very limits. But we're also at the most technologically advanced moment in human history. And this is the same for us in Nigeria, with artificial intelligence, the Internet of Things, and now even 5G, redefining commerce, medicine, entertainment, and even how we work and play. The conflation of these events is both enormously, in my view, exasperating, but it's also incredibly a hopeful time. And for our system of justice, it offers great opportunities, and we must not in any way diminish those opportunities that it offers. But we are faced today with demands for both structural and philosophical change in our administration of justice system. And I cannot, I can't but help repeating, how well Fidelis put a lot of these issues. But the big question is also the relevance of our paradigms of justice to the major socioeconomic circumstances that confront us. The law is a social construct and makes sense only within a social context. To treat the law as something apart from society or as a body of technical abstractions is to strip it of meaning and to alienate the legal order from the very people that it is meant to serve. Consequently, a definition of justice that focuses on social and economic rights of the people is not only meaningful, it is certainly more just. Of course, these rights, as we know, include the right to shelter, food, employment, education, a reasonable standard of living, a national living wage, a national minimum wage, care for the elderly, pensions, unemployment benefits, and the welfare of the physically challenged. Our progress in the observance of socioeconomic rights must also be prosecuted in terms of the struggle to reduce the basic problems of ill health, malnutrition, illiteracy, farming, etc., which daily afflict our people. Where social and economic rights are unsecured, people are unable to fully maximize their civil and political rights. So, for instance, access to qualitative education enhances and enriches freedoms of expression, thought, and conscience. Conversely, pervasive illiteracy can nullify the entire idea of freedom of expression. In the progressive vision, political rights and socioeconomic rights are mutually reinforcing. But socioeconomic rights, even where they are wholly justiciable, mean nothing unless there is a fiscal commitment to enforcement. And so this is crucial, because it's a crucial, in my view, intersection of politics, of ideology, and of our notions of justice. And this may explain why the opposition in Nigeria was prepared to abolish our social investment program if they won, while our party's understanding of the imperative of delivering social justice was the provision of a massive social safety net, or at least the beginnings of the provision of a massive social safety net. This was a fundamental feature of the party's manifesto. So our social investment program, which is possibly one of the most ambitious welfare programs on the continent, and our effort to expand universal health insurance, all aim at ensuring that our most vulnerable citizens are not abandoned to the vicissitudes of fate. Consequently, socioeconomic rights, where they find fiscal support, is absolutely crucial. And if they don't find fiscal support, obviously, the whole cause is lost. It's of course evident that without social justice, legal justice, in any sense, is unattainable. The degree to which citizens are in possession of their socioeconomic rights also has a direct impact on the degree of their access to legal services and thence to justice. Our Constitution asserts that the independence, impartiality, and integrity of the courts of law and easy accessibility thereto shall be secured and maintained. It's significant that the framers of the Constitution enshrined access to justice along with socioeconomic rights in the directive principles and objectives of state policy. And this indicates clearly that they saw access to justice and the integrity of our justice system and socioeconomic rights as related imperatives. And I think that's the right construct, that's the right framework. There's also a growing recognition, especially in criminal justice, that the model of adjudication that we're accustomed to, which largely dispenses retributive justice, is not entirely adequate to meet the demands of justice in the various complex scenarios and situations that confront a developing country such as ours. Given the tensions and frictions generated by contending passions and grievances and the social reality of inequality and inequity, there's also a recognition that some of the most serious situations, which threaten to even sometimes, break the fabric of society, require much more than just retributive sanctions by a judicial system. They require restorative justice to bring about healing and the reconstitution of communities. This is one of the approaches that we're looking at as part of our efforts to resolve protracted ethnic and religious conflicts. In many, many cases, it's not enough to arrest, detain, and then prosecute and jail a terrorist or jail someone who has abducted children for years. There is a need somehow to find a process by which restorative justice can be brought to bear, by which the communities can feel somehow, by which their feelings of violation can be assuaged. Already the National Policy on Justice embodies some of these prescriptions and offers pathways of innovation for more holistic approaches to justice delivery. There's still much work, of course, to be done in this respect. But just to mention as I close, just a few of the issues which I've described as infrastructural issues. How do we ensure that we attract and appoint only the best amongst us to the bench? How can we do, what can we do about unreasonable delays in justice delivery? How will technology affect our administration of justice system? What needs to be done to maintain the integrity of our judicial processes and outcomes? To take the easiest first, and I'm not going to make any elaborate comments, as I said, I endorse fully practically everything that Fidelis said. There's little doubt that technology has already permanently changed the way we do business. The Supreme Court, in the wake of the pandemic, endorsed virtual court proceedings. So, I mean, clearly, at least the doors have been opened for whatever the implications of virtual court proceedings mean. Digitization of trial processes is now inevitable, and there are very many easy-to-use models. This will by itself, in my view, impact trial times. Recording proceedings will be easier, and so will several other things. And I agree with Fidelis that sometimes technology might be slower than manual processes, especially because we haven't got the technology right. But I think that with more frequent use and with states like Lagos, we'll probably get it right much faster. You know, we've been at this issue of digitization for quite a few years now. But I think that it's getting much easier to adopt some of the best models that there are. But the important correlation between the cost regime and the speed and efficiency of trials, again, is a very crucial issue. We cannot have the cost regime we have today and expect that lawyers will not engage in dilatory tactics, especially where the lawyer knows he has no case. So really, I fully endorse what Fidelis has said in his presentation about how the cost regime should influence the way that trials run, and also how dilatory tactics are punished by the sorts of costs that have to be paid by counsel that engage in such conduct. We must take the opportunity also to rewrite procedural rules, to remove needless processes and rituals. And I think, again, to the point that Fidelis made, this entire approach of just a completely technistic way, it really has given rise to the most absurd outcomes. The obsessive, and I think that's the word he used, elevation of form over substance. This is obviously a matter that we must take seriously, and it's a matter that we must address, not just as professionals, but we must involve all the arms of government. I had the privilege of speaking at a webinar on appointment of judges, I think about 2 weeks ago, and this matter also came up. I think it's important for us to sit together, that is to say, the leadership of the legal profession, the executive, judiciary, and the legislature, to take a second look at some of these issues, because really, what's the point of the whole I mean, if you look at judgments, just as you said, some of the judgments where there's just been an unnecessary emphasis on technical outcomes, where in fact the entire justice of the case is just made ridiculous. I think, when a case is decided right, when justice is done, there is practically everybody feels that justice has been done. And it's not a very difficult thing to achieve at all. I mean, and I think that every time that technicality is raised over the justice of the case, it just leaves a sour taste in the mouth, and everybody does feel that something has been violated. So it shouldn't be a very difficult thing at all to get the justices of the Supreme Court and a lot of our justices to understand, what needs to be done and to do what is required. On judicial appointments, it's clear that a merit-based system is absolutely necessary. We need to insist on mandatory tests and interviews for all applicants, and I'm sure that this matter will be addressed in detail by, I know we have someone from the UK judicial appointments who will be looking at the system in the UK, but clearly we need to look more carefully at how our judges are selected, and there has to be an objective process of selecting justices. And we cannot insist that the only way to become a judge is to be a career person, or at least to move from High Court to the Court of Appeal and Supreme Court. We must be able to bring in practicing lawyers. We must be able to bring in academics to be justices of the Court of Appeal, to be justices of the Supreme Court. And if it requires rewriting the rules, then let us rewrite the rules so that this can be made possible. Besides, I think that the point which has been made again by Fidelis about the fact that we're not going to get angels to reform our system. It's going to be done by ourselves. And I think we in the legal profession, even if only for self-preservation, even if only to preserve our own profession and our means of livelihood, if we have no higher objectives, we owe it to ourselves to change all of what we're seeing. And it means engaging with the Supreme Court. It means engaging with government, with the executive, and with the legislature fully to change some of these rules. And I think the case is very clear and evident one, that change is necessary, and that the reform of our judicial system is urgent. Every minute of delay simply worsens the bleeding. So just to say thank you again for the very kind invitation and for this opportunity, and I'm looking forward to some of the discussions as we go on. Thank you very much.
Thank you very much, Your Excellency. It's always a pleasure to hear from you.